Good afternoon, everyone. Thank you for joining us today for today's online talk. Our talk will be starting shortly at 3 p.m. So for those of you who are here early, thank you for waiting patiently. While waiting, we would like to share you with a very short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Defamation Allegations in Strata Management. My name is Marilyn Tay. I am the Senior Associate with Malice & Associates, and I'll be your moderator for today. So before we start today's talk, let me introduce the firm and what we do. Malice & Associates is a mid-sized law firm that was founded in 1985 by our Datuk Ma Wing Kwai. Our able team today comprises 30 lawyers and support team of 23. Datuk Ma is today the consultant of the firm, following his retirement from the Court of Appeals bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment or industrial relations team, and a department focused on servicing the needs of individuals and families. We have various practice groups indicating some of our focus areas, which are supported by talents from both our corporate and dispute resolution team. Today's talk is part of our MWKA's online talk service. By way of background, we have been organizing monthly lunch talk at our office since year 2013, some of which were also broadcasted live. Since the implementation of MCO due to COVID-19 pandemic, we have moved our talks online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsels. Before I continue, please be reminded that this talk does not constitute to any legal advice. In the event that you require specific legal advice to your matter, please feel free to contact us for a complimentary legal consultation. Details will be given at the end of this talk. So our speaker today is Mr. Edwin Raj. Allow me to introduce Edwin. Edwin is a Senior Associate in our Dispute Resolution Department. He holds a Bachelor of Law from the University of London, and he has obtained his Certificate of Legal Practice, or better known as CLP, in 2014. His key areas of practice include general litigation, defamation, debt recovery, joint management body disputes, employment matters, and also intellectual property. We will also be having a Q&A session at the end of the talk. So if you have got any questions from the speaker, please post them into the Q&A chat box at the bottom of your screen, and we will address to it at the end of the talk. The talk points for today are: what is defamation, defenses to defamation in strata communities, and tips for avoiding defamation. I'll pass the time over to Edwin. So Edwin, here you go.
Thanks, Marilyn, for the warm welcome. Thank you guys all for attending this talk. and joining us today on Wednesday, on this lovely afternoon. I've received feedback that we've received an overwhelming response of about 130 participants. Thankful for that. And I hope that throughout this session, you'll gain some insight to defamation and also in the context of strata management. Okay, I will run through the top points again. Without further ado, I will speak about what is defamation, a brief introduction, the defenses to defamation. So in the event you receive a defamation suit, what can you do? And then I'll zoom into defamation in the context of strata. That means examples of a defamation that goes around during a strata community event. And also last but not least, tips for avoiding defamation. Okay, so before I explain what is defamation, I would want you to understand that the rationale of defamation laws. Okay, the rationale here is that the courts are concerned with balancing the competing interests. Two balancing interests. One is the protection of reputation. The other is freedom of speech. Okay, why is it important? Because yes, someone has the freedom of speech to say anything they want, but it has to be balanced and curtailed, right, with the other balance, which is the protection of someone else's reputational rights. You cannot be saying like, just because I have freedom of speech, I can just say whatever I want, even though I attack someone else's reputation. So the court is always thinking about this whenever there's a defamation suit, right? Balancing interests of both these two interests. So defamation is governed under Defamation Act and also common law. What is common law? Common law is judge-made laws. Okay, basically simply means judge-made laws, not necessarily enacted by Parliament, so by way of judicial precedent. So there are two types of defamation. Okay, you have libel and slander. See, libel, what's the difference? Libel is when statements are made in the permanent form. This could be, for example, typing something out in your social media. Okay, statements in your social media. Once it's out there and published, it is in the permanent form. So that would be categorized under libel, whereas slander would be more or less relating to words or gestures made. So it is temporary and it's not permanent. So now let's move on to what is defamation. Now, the law defines defamation as this. Defamation is the publication of a defamatory statement to a third party. Not really helpful in understanding what defamation is, right? But let's break it up to three key elements that you have to satisfy in order to succeed for defamation. Number one, a statement must be defamatory. Again, not very helpful, but I will go through with you in the later slides. Number two, statement refers to the plaintiff. So whatever statements that you think are defamatory must refer to someone, okay? It cannot be a group of people. I'll discuss this later as well. And number three, the statement is published to a third party. Now, published to a third party basically means, publication basically means communication to a third party. Okay, I will address this later as well. Now, the first element, what is a defamatory statement? Okay, the law also defines what is a defamatory statement as this: a statement which tends to lower a person in the estimation of right-thinking members of society generally. So I understand that this may be a bit complex and difficult to understand, but what it basically means is this: any statements who are made against a person and attack on that person's reputation, which lowers his reputation in the eyes of society, that is a defamatory statement. So any attack on someone else's reputation, which lowers his reputation in the sight of society, makes it a defamatory statement. I hope you understand by that. If you don't, just feel free to ask later. I'll just explain it again. Okay. A much simpler explanation can be found in the second one. These are also defined in laws. Defamatory statements are statements that exposes the person to hatred, contempt, or ridicule. Okay, so for example, statements such as, "Oh, that person is a racist," that exposes that person to hatred by others. So that is a defamatory statement. It can also be statements disparaging, statements that are able to discredit and injurious towards the person's reputation in office, profession, calling, trade, or business. So for example, if someone else puts in a comment, "This lawyer who is speaking right now in the webinar is not doing a good job, he doesn't know the law," and things like that. That is a defamatory statement, right? Because it lowers the reputation of the speaker. Okay, now there is a test. The test provided by the court to see whether a statement is defamatory or not. Okay, the test is this. The court will use the meaning of words in its natural and ordinary meaning conveyed to an ordinary person. And the court sees this as an objective test, not a subjective test. Your subjective understanding of the words may not be relevant. Okay, say for example, I have a very close friend and I always, by banter and as a running joke, I always call him Drunkard Joe. So I always refer to Drunkard Joe, I speak to him, I casually call him Drunkard Joe. But when I speak about Drunkard Joe to another person, say for example, someone who I've just met who knows Joe as well, and I call, oh, I know Drunkard Joe. Drunkard Joe is that guy who, me and him are close friends, he's a drunkard. Now, the court would not consider whether what your subjective understanding, meaning the court would not care that you had a previous relationship with Joe, you used to call him Drunkard Joe, it's an ongoing banter and all that. No, the court will view it in the eyes of the ordinary person. That means the new person who just met Joe. What would he think when I say Drunkard Joe? He will probably think, oh, Joe is a drunkard. Maybe then the effects are, I don't want to associate myself with him, and therefore his reputation has reduced. So it must be an objective test, not a subjective test. And because of that, I may be liable for defamation. Okay, hope that is clear. Next, publication must be read as a whole, not in isolation. What I mean is this, you know how journalists, they like to sensationalize things, right? So in their articles, they always write beautiful titles to it. So it can be, for example, something like politician X caught red-handed. Okay, so you might think that, okay, saying something serious, there's a serious allegation against politician X, but when you go on to read the entire article as a whole, it seems to suggest that, oh, caught red-handed, but it was during a charitable event. They had to paint their hands red and something like that. So what I mean is that the court will see the entire article, not just the title itself. So when determining whether a statement is defamatory or not, you cannot just pick and choose the statement in isolation. You have to read the entire article and then determine whether those statements in that entire context is defamatory or not. So for example, okay, we are going into more strata-related issues. Take these two examples. Okay, unit owner X is rude, toxic, and is spreading rumors about the management. Please do not be influenced by him. Is that a defamatory statement? Compared with the next one, please refrain from spreading rumors about the management. Please visit our office to raise any pertinent concerns or issues with the management. Now, which do you think is more of a defamatory statement? It's quite obvious that the first example is more of a defamatory statement, right? You use words rude, toxic. So those are defamatory statements because if it's found to be false, owner X may sue you for defamation because you're lowering his reputation. Another example, during an AGM, please do not vote for X as he is known to be lazy and has a history of failing in his business. Again, is it defamatory? Yes, it is defamatory because you're saying that he has a history of failing in business and is lazy. Unless you can prove that you have evidence that he has been lazy and he has been failing in business, you may succeed in a defense, which I will speak about later. But if it is false, then you may be liable for making a defamatory statement. Now, social media, our beloved social media, we love to, during our riled up moments and emotions are high, especially after an AGM, we just want to type everything all out and rant to our friends on social media. So if you say something like Management X is the worst management company, they do not know how to run the management of a building, that is a defamatory statement. Okay? Committee meetings, right? Committee meetings sometimes can be heated, and then one person makes a decision, you're not happy about it. Then you hear things like the chairman is abusing and misusing his position in making arbitrary decision. Abusing and misusing, those are defamatory statements. Now, let's come back to the second element, okay? That means even if a statement is defamatory, doesn't mean you will succeed in defamation. You will still have to prove two other elements, which I discussed earlier, and one of them is reference to the plaintiff. Now, the statement must refer to the plaintiff. This is very straightforward. During an AGM, I think there are unit owners who are conducting illegal activities inside the apartment. It's a bit vague, but there is no particular reference to anyone, any individual. Compared with the next one, I believe unit owner A1109 is conducting illegal activities and should be reported and punished. Now, what if it is not true? What if it is not true? If it's not true, there is clear defamatory statement, which is he is conducting illegal activities, and there's reference to the plaintiff. So here you are referring to that specific owner. That is what we mean by reference to the plaintiff. Now, publication to third parties. That's the final element. Publication here doesn't mean you're publishing of newspapers or things like that. Yeah, publication here simply means, as I've explained, communication to third parties. It means whatever you have mentioned, an attack on someone else's reputation must be communicated to a third party. So, example, if there's in a room of two, there's two persons present, and I speak about that other person who's present, and I attack his reputation, I won't be liable for defamation because there's no communication to a third party. There must be three at least present there. Now, you may ask, what if I'm not the original author? Okay, so sometimes you see in your WhatsApp group messages, right? You see someone typing very negative comments about someone in particular. Owner X is so lazy, he's not doing his thing, blah, blah, blah. Now, you agree with that statement and you want to forward it to your other groups. That's called republication of that. Is that a defense? No, it is not a defense. Okay, republishing someone else's defamatory statement can also make you liable for defamation. Okay, now the role of publication, of course, comes within the context of damages. What I mean by damages is the compensation. So if, say, for example, you succeed in a defamation suit, the court will take publication as a factor in determining how much one party should make because of that defamatory statement. So let's say you make a slanderous remark because it's temporary, the damages of compensation, which would be much lower compared to if you publish it in social media, permanent form, and your audience is so wide that your reputation is very much affected compared to slanderous remarks. All right. Okay. So I've basically covered what is defamation in the shortest amount of time. So I hope you understand from my brief explanation some of the key points in defamation. And now let's go to the defenses. In defamation, there are many more defenses than what I've listed down here. I've picked up 3 out of the many because I'm of the view that in strata context or in strata committees, these are the most relevant defenses available. You have justification, you have fair comment, and qualified privilege. What is justification? Justification simply means proving whatever statement that you made, even though it's defamatory, is true. So essentially, you're proving the truth of that statement. As simple as that. So section 8, I know it's too long. I've put it out there, but I think it's a bit too complex. But essentially what it means is this. All you have to show is that the statements you made is true or substantially true. Once you're able to prove that as a defendant, you will be afforded the defense of justification. For example, let's say in your strata property, there is a chairman, and that chairman personally appointed a property manager. And later on, you found out that, look, they have other business relationships together, or they have certain personal relationships. Okay, you find that they are directors of certain other companies. And you've done a search in the SSM, and it is indeed true. Now, if you make a statement about, hey, chairman, you have personal relationships, business relationships, and I think there's a conflict interest and it's unfair to us that you did not inform to us about your relationship, those statements cannot be defamatory, or even if it is defamatory, it is justified because you have evidence to prove the truth of your statements. This is based on a case law, yeah? This is based on Ching Wing Wah and Ang Kok Hui. What the court stated was that you must be able to prove that the chairman has vested interest in the building manager or agent company. Simple terms, justification, if you're speaking about the truth, even if it's defamatory, you will be afforded the defense of justification. Now, let's go on to the next one. Fair comment. What is fair comment? Section 9 is governed under Section 9 of the Defamation Act, and there are 4 elements to be satisfied. First, it must be comments, not statements of fact. Yeah, it's fair comment, not fair fact, right? The comments are made based on true facts. Okay, you're making a comment or an inference after knowing there is truth to a certain fact. I'll discuss this later. Comment must be made on matters of public interest. And then finally, you have comments must be fair and honestly held. Now, you may ask, what's the difference between comments and statements of fact? Fact is very clear. Allegation of fact is like, okay, he's corrupted. Those are allegations of fact. Whereas comments are inferences, opinion. on deduction and observation. Take, for example, the scenario that I've put in the slides. He stole the monies which was to be paid to the management corporation for maintenance of the building. That is an allegation of fact. You're alleging that he stole the monies. Okay, compare it with the one below. It is very suspicious that the monies in the corporation fund was transferred to his account. Those are comments. Why? Because you're making a comment. The comment here is suspicious. And the comments are based on true facts. The true facts probably in that scenario is that you have evidence that the monies were transferred from the corporation fund to his account. You have evidence to that. So that makes it a fact, a true fact. And because of the true fact, you make an opinion about it or a deduction or an observation. And your observation is that it is very suspicious or is highly suspicious that, look, monies are entering into your account. And I think that's very suspicious. Rather than saying an allegation of fact, which is because the monies are in your account, you stole the monies. Okay. Now, it's important to make comments rather than facts, because you may not know the reason why certain things, even though in the most dire or negative situation that it may appear to you, there may be a reason that the plaintiff could justify. For example, he may say, oh, because the corporation fund, somehow the banks screwed it up, they were going to froze the accounts. So because the management or the property required urgent maintenance, they had to shift the monies to an account to get it sorted out for the maintenance fee. There could be an explanation like that. So it's best for you to make comments rather, or observations and opinion rather than allegations of fact. Now, we have covered the two key points. There must be comments, and those comments must be based on true facts. Now we will go to the next two. Comments must be made on matters of public interest and must be fair and honestly held. So I will go into what is public interest first. Okay, public interest is a matter is such as to affect people at large so that they may be legitimately interested in or concerned at what is going on or what may happen to them or others. Then it is a matter of public interest. Basically, it affects people at large. So in the context of Strata, don't worry, because majority of the occasion when all these comments are made, especially during the AGM, affects people at large within the community. So it would be considered a matter of public interest. So you don't have to worry in the context of Strata. Yeah. So now, what is fair then? The law defines fair as comments that are honestly made in absence of malice. I'll discuss malice a bit later, but simply means that you do not have ill intention when you make those comments, that you're genuine in your statements. For example, the account situation again, you knew the reason he was transferring the funds to his account because he wanted the management corporation fund was being frozen, and because urgent funds had to be given for the maintenance of the building, that's why it's in his account. But if you knew that, and yet you made that comment that it is highly suspicious and so forth, without bringing the fact that you knew that there was a reason to do so, that would be malicious. But I'll discuss what is malice a bit later. For now, let's go to the final defense that I would like to discuss with us today, qualified privilege. Now, what is qualified privilege? Qualified privilege is a unique defense in comparison to the both by what it simply provides protection based on. Instead of saying that it is not concerned, look at the third sentence, focus is not so much on the contents, but on the occasion that communication is made. So court doesn't find it relevant whether it's defamatory or it's false or not. It can be defamatory, it can be false, but yet you may be able to rely on qualified privilege if the occasion allows you to do so. Now, in what occasion? In occasion simply means the circumstances allowing you to make those defamatory statements. Yeah. So this is the test. Qualified privilege is an occasion where the person who makes a communication has an interest or a duty, be it legal, social, or moral, to make it to the person to whom it is so made, has a corresponding interest or duty to receive. The reciprocity is essential. So the occasion is when one party, the person who makes that statement, has the interest or legal, social, moral duty to make those statements, and the receiving person has the corresponding legal, social, moral duty to receive it. And when there's this reciprocity on duties, there is it creates a circumstance or an occasion of qualified privilege. Okay, I'll give you an example. I know it's a bit hard to digest this, but I'll give you an example. Say, for example, your children is going through college, okay, and you have your lecturers, there's three parties here, the lecturers, the parents, and your children. So let's say your children have been not attending classes, have been disrupting classes and all that. So the teachers, the lecturers have a duty, a social or moral duty to inform you about the behavior of your children to you as a parent, and you as a parent has that corresponding duty to receive it. So there's this reciprocity between the parent and the lecturer. The lecturer would probably say, I have to inform you that your child is not attending classes and he's being disruptive and I don't know what's going on and all that. And you have that duty on receiving it as parents. Now, your children cannot sue, or even if they sue on defamation, the lecturer can rely on qualified privilege. Why? Because there's this reciprocity of duties. Now, in Strata, how does this happen? Usually, when you make complaints through the proper channels, when you make statements or about anyone or any complaints made through the proper channels, it is more than likely that you are able to rely on the defense of qualified privilege. Now, proper channels such as during the AGM meeting, okay, you as a unit owner, you have a duty, okay, a social and moral duty to inform the other unit owners like, look, the chairman has done this and that. And at the same time, all the other unit owners present there have the reciprocity or the corresponding duty to receive those complaints or concerns that you are about to raise. So that will create an occasion or circumstance of qualified privilege. In Strata, here I've listed, you have AGM meetings, committee meetings, publication of minutes, publication of notices, letters of complaint to the COB. These are more or less proper channels to raise your concerns. If you raise your concerns in social media, does that create an occasion of qualified privilege? No, I don't think so, because there's no corresponding duty for your audience. Your audience is so wide, it could be your friends who is not even in the Strata community, and therefore it does not create that corresponding duty that I have just explained. Now, let's go on to malice. Why malice is important is because the two defenses that I have just explained, which is fair comment and qualified privilege, are defeated by malice. What is malice? Statements made without believing it to be true, indifference towards the truth, recklessness towards the truth, especially when the defendant had avenue to inquire the truth of it. So if, let's say, the lecturer's example again, if the lecturer knew that your child or the student was disrupting classes because of severe issues, health issues, or he had serious problems, then despite knowing that, and if he still made those complaints to the parents, that can be malicious. Because he knew the truth. Instead of bringing it up to the parents, look, I know your son is facing this problem, but I think he has other problems. That's why he's disrupting the class. Those would be not malicious, but if he knew and he kept it from that parent, that would be statements made maliciously. Okay, and that would defeat the defense of qualified privilege. Recklessness and indifference towards the truth also would be considered malice. This happens, say, for example, very rampantly in journalism. So, for example, they get information, inside information that, oh, this politician has done something wrong. Sometimes, rather than checking, they always have time to check with the politician, but because journalism, they are racing towards the other journalist companies, they would try to be the first one to publish those statements first, without checking the truth on that information. So sometimes those failure to verify those information can be considered indifference towards the truth and recklessness, and therefore it can be considered as malice, and it will definitely defeat the two defenses that I mentioned, qualified privilege and fair comment. Finally, we have wrapped up what is defamation and what are the defenses of defamation. We are moving on closer and closer to the strata context. So now, what happens if you as a committee member, you're doing your job, you're just stating what the report states in the AGM, you're raising concerns about certain unit owners who are abusing things or doing something which is not right, and then you receive a suit as committee members. Isn't that very unfortunate that you're actually spending time out of your own time, money, and effort to help and write, and then you get a suit still, nevertheless? Wouldn't that deter people from being committee members? Okay, what happens? Now, the court has decided if suits are filed individually against the committee members instead of the management corporation, committee members can actually file a striking out procedure to dismiss the entire claim. Now, striking out is a technical court procedure where the defendant can file this application. You can throw the claim entirely out because it is not relevant and it should not be filed against that person. That is what simply striking out means. So we will examine briefly the case of Taufik Ayman, where the members were personally sued and the management corporation was sued as well. So what did the court say? This involves a management corporation, and also the others, the second defendants onwards, were all committee members. They were sued due to bringing up an issue about an unauthorized installation of booster pumps in the common area. Now, the plaintiff here claimed that, look, I did seek authority, and because you raised it in the AGM as if the installation was unauthorized, that is actually defamatory. Because the suit was filed personally in the individual's names, the second defendant, who are the committee members, the chairman, and the other committee members filed a striking out because they say you should be only filing the suit against the management corporation. Now, the court decided that the defendants can only sue the management corporation and not the committee members. Now, why? The court found that why you can only sue management corporation and not the committee members, because the committee members were just performing their duties as in their official capacity as provided under the Strata Management Act. So they were dealing with issues about Strata, and because they were committee members, they raised those concerns in the AGM. Now, because they were doing that, they were in their formal capacity and discharging their duties. And the fact that the management corporation, by virtue of Section 39(2) and 2A of the Strata Title Act, a management corporation is a legal entity. It's a body corporate that can sue and be sued, just like a company. So because whatever the committee members said were done on behalf of the management corporation must be sued instead of the committee members. The court relied on this case, Baharuddin Ali. It states this: the law is clear that in no cause of action in defamation would lie against an employee or a managing director of a corporation in respect of a publication issued by a corporation. If you are discharging your duties as a committee member and you receive a suit naming you personally, you can file a striking out and dismiss the entire claim because it should be leveled against the management corporation. Because whatever you are saying, you are doing on behalf of the management corporation. Sometimes the plaintiffs sue the committee members because they do not see the legal entity of the management corporation. Because the management corporation, there's no person in it, right? It's a legal entity, but during an AGM, you don't see the management corporation. You see the people behind the management corporation. So that is why they usually name those individuals, which is not right. You should be leveling those claims against the management corporation, especially if it's in discharge of their official capacity. The court struck out the claim against all the committee members. This is another scenario. I will not go through those because of lack of time, but it was similarly held because the suit was only filed against the chairman. And since he was named as a chairman instead of the corporation, the chairman was able to strike out the suit. Now, let's just absorb whatever we have learned just now, okay? From what is defamation, the elements of defamation, the defenses available, and let's go through a real scenario, a case scenario where a suit was filed in the Strata context, okay? And then I want you to go through this case law and just at the back of your mind, just analyze, okay, are those statements defamatory? What do you think the defenses may be available to those who are sued for defamation? Before I cover and I explain to you what the court decided. So this case involves the area of the property of Megan Avenue Management. The plaintiff are lawyers and they are registered owners of 3 units in Megan Avenue. The first defendant is the management corporation, the second defendant is the property management company, and the 3rd to 9th defendants were committee members of the management corporation. What happened? The property manager posted a list of names of unit owners, including the plaintiff, who had outstanding dues in a notice board of Megan Avenue. But what happened? Immediately on the second day of posting, they took it down And they issued an apology to the plaintiff, the lawyers as unit owners, because they found out that the lawyers or the plaintiffs actually had at that time already paid the outstanding dues. So technically, there was no outstanding from the plaintiffs, but yet the property manager put down a list and said, look, plaintiff, you have still owed some, please pay. So that's why, aggrieved, they filed a defamation suit. Now I want you to consider whether is posting this list defamatory? And if it is, what do you think as the property manager or the committee members, what do you think, what kind of defenses would you be able to raise? Okay, the thing for court to decide was whether the word outstanding is defamatory and whether there was malice in the publication of the list. I'll go to this. The court found that the words outstanding appearing in the list was not defamatory. They found that the words outstanding itself does not denote any defamatory or any lowering of the plaintiff's reputation at all. Why? Because the court, relying on the dictionary, which defined outstanding as unpaid and not yet done or settled, is not defamatory. Because the court was of the view that it would only be defamatory if you say that instead of outstanding, you say like the plaintiffs are unable to pay, they are debtors, they are bankrupts when they have actually paid. If they have actually paid, then the court was of the view that those statements would be defamatory. But however, in this context, the court found that outstanding simply means, look, it serves as a reminder. Please, you have not paid this, please make your payments as soon as possible. That was what the court found, what outstanding meant. Okay, unpaid and not yet done or settled, please pay. Now, the plaintiff at that point did raise a case law, Saharuddin, where for that case, at the time of issuance of the letter of debt by Bank Islam, the debt had already been settled. Similar to this case, one is outstanding, here is debt that was settled, but the Bank Islam still issued a letter of debt in full, and Bank Islam had acknowledged that plaintiff had fully settled his debt. There was no reason for the defendant to issue the letter to the plaintiff. Now, in this case, the court found that by you still saying someone is a debtor, even though he has already paid and you have recognition that he has already paid, by you mentioning that he is a debtor is defamatory. Now, compare this with this case where the court said outstanding is not defamatory, because I'm not calling you a debtor. I'm just giving you a reminder based on the list that, look, there are outstandings to be paid. I hope you can see the difference there. Now, okay, what do you think are some of the defenses that could be raised if the court found that outstanding was defamatory? Now, here, the defendants raised the defense of qualified privilege. Okay, they raised the defense of qualified privilege. The court also delved into qualified privilege because the court said, okay, even if I was wrong to find that outstanding was not defamatory, let's consider whether qualified privilege applies here. The court found that qualified privilege applied because of Section 6.3 of the third schedule of Strata Management, Maintenance and Management Regulations 2015, which basically says this: the management corporation may prepare a list showing the names of defaulting proprietor, their respective parcels, and the amount of the sum that remains unpaid, and may display the list of defaulters' names on the notice boards in the building, provided that such list shall be updated by the management corporation at the end of every following calendar month. So the court said, by virtue of this regulation, providing it to the defendants, the list, whether even if outstanding is defamatory, by providing that list, there is a corresponding duty to provide that list to owners to know that, look, these are the defaulters, and at the same time, the owners have a corresponding interest or duty to know who owes money in terms of maintenance fund, and therefore this entire list, posting of list scenario, creates a situation of qualified privilege. So therefore, the court said that even if I was wrong in finding that outstanding was not defamatory, the defendants could rely on qualified privilege. Okay, and there was absence of malice here. Okay, the list was not prepared with ill intention because the plaintiff here did not forward the proof of payment. The management corporation did not know that they had paid. And the fact that they promptly took down immediately when the plaintiffs notified them, like, look, I've already paid. Once they have mentioned that, the corporation immediately took it down and apologized for that mistake. Once they apologize for that mistake, it is very difficult to say that someone has made those statements or the list was done maliciously. Now, I'm going through the final phase or final part of the talk where tips on avoiding defamation in context strata. Okay, after everything I've explained to you, I just want to give you some tips to avoid defamation, because why would you trouble yourself to be open to a suit and you have to engage lawyers and then you have the whole trouble of trying to settle this matter, and trial process takes a very long time. So the best option for you is to avoid defamation in its entirety. Okay, and how do you do that? Be careful with words, especially in the permanent form. Think thoroughly. Okay, be very careful. Think once, twice, 3 times, 4 times when you want to post something which is in permanent form, especially in your social media and WhatsApp groups. I understand that WhatsApp groups, you feel very free and it's very instantaneous. You press it and it's sent, it's published to so many people. But you have so many avenues to think about it. You can type it down. You can think whether, am I crossing the borderline of defamatory statements or not? You can go through based on the insights that I've given you. Am I crossing that line, and is it worth to cross that line? Okay, think 2 times, 3 times. Be careful when you publish those words. Now, especially statements that reflect negatively on another. Okay, no one likes to hear something negative about themselves, right? So if you publish something negative, especially negative stuff, be very careful with that. Of course, if you publish something positive about someone, even though it's a lie, I don't think anyone would mind that, right? Okay, the next one. If you absolutely have to say something burning inside during the AGM, you have to just raise it. I cannot take it anymore. I just need to say it out. Think carefully, okay? And if you have to absolutely say it, craft what you're about to say. Avoid ambiguity. You know why? Because when you leave ambiguous statements, the lawyers will capitalize on it. So for example, you say, okay, that chairman has been using funds for, I don't know what reasons, and everything seems to be not useful. So when you're ambiguous, the lawyers will capitalize and say, oh, because you said that, you're saying that the chairman is corrupt, the chairman is arbitrary, the chairman is so this and that and this and that. The lawyers will find a list of anti-things and say that you're actually trying to insinuate that against the chairman. And you would be in much more difficulty when you actually meant to just say, oh no, I think he has just not used the funds appropriately. That's all. Now, of course, the fourth one here, only say what you can prove. This goes back to our defense of justification. Say what you can only prove. But if you cannot prove a statement, why do you have to say it? You can raise concerns in the form of comments, but say only what you can prove. Use the language of opinion. That's what I meant. Use the language of opinion. Oh, I think that because this event and that event has happened, I think it's not appropriate for you to do this. Please, can you please explain to me why you did this? Be more neutral rather than very aggressively attacking someone and alleging it as a fact. Of course, it goes without saying, avoid name calling. You don't want to be calling someone, drunkard in the AGM. I saw you drinking during the day, you're not working. Try to avoid name calling. Avoid republication of statements which are potentially defamatory. This is what I mentioned just now. If you receive anything, WhatsApp group, defamatory about someone, try not to forward to anyone. Just leave it be. Just let it be. Let it come. Don't have to chime in anything, especially when those statements are defamatory. Now, apologize if you made a mistake. This will help you with your defenses, because if you do not apologize when you realize there's a mistake, then it could be malicious. And malice will defeat the 2 defenses that I've mentioned just now. Finally, adopt the bane and antidote approach if absolutely necessary. What is the bane and antidote approach? Now, the bane and antidote approach is, rather than saying a statement or putting the statement, the sting of the statement, you put an antidote to the sting as well. So what I mean by that is that, let's say, you can say, oh, that chairman, his behavior was inappropriate, he was doing this and that and everything, but that's the bane. The bane is inappropriate, he was doing this and that. But the antidote here is that you can say, but I've known the chairman for long. I've known the chairman for 5 years. He has been nothing but perfect. He's been a good friend. He's been responsible and so forth. So in that entire statement, there's not just the sting and the bane, there's also the antidote, which neutralizes everything and makes everything less defamatory. I'm finished with my talk. I'll give it back to Marilyn. Thank you.
Okay. Thank you, Edwin. Thank you very much for your sharing. So it's definitely an insightful one. So we will now start with our Q&A session. The first question that we have today, I'm in a WhatsApp group of a couple of unit owners, and I saw an owner posting something defamatory in the group. Will I be in trouble if I don't do anything about it?
So if you do not do anything about it, inaction cannot be defamation. So if you are just inactive about something, someone cannot just file a defamation against you. Because if you are silent about something, that won't attract defamation. If that was defamatory, then the fact that if I speak to an audience and if I make defamatory statements to the audience, those audience will all be open for defamation suits. To answer your question, no.
Thank you, Edwin, for that. If I have strong evidence that the committee members are misusing funds, how do I raise them to the attention of the other unit owners?
Okay, to avoid defamation, I would say first, make sure that you have evidence that person is misusing funds. Number two, use the official avenues to raise those concerns. Remember what I said about qualified privilege? You can go to the AGM meetings or official complaints, personal letters to the management corporation. Look, I have serious concerns that there are some mismanagement of funds. Why? Give your evidence and say, I just want to know a reason or an explanation to do. So try to raise it in the official avenues. I would say raise it politely in the AGM setting that would afford you certain defenses that we have discussed earlier.
Thank you, Edwin. That's definitely a very good tip for us.
Why defamation cases increase by the day in strata management? When MA in question felt that they are likely might not be renewed or not renewed. So MA, I will presume the managing agent, is it? I think MA means managing agent, but why are defamation cases increasing by the day in strata? To prove defamation, first of all, you must go through all the elements that I've just discussed. And if you are sure that the managing agent are using defamation suits as a tool to stop you from raising concerns, you can defend that and you can ask for costs against the managing agents. Now, as long as you follow those tips that I've just discussed on how to avoid defamation or how to raise issues and concerns or complaints about the managing agent, then if you do that in those occasions, it is more than likely that those defenses will be available to you. And if at all, the claims filed by the managing agent would be frivolous and would be struck out. Any other questions, Marilyn?
So the next question that we have from the floor. So would another example of qualified privilege be, say, a doctor who has been told by
Expecting teenager not to inform her parents.
Doctor who is a friend of the teenager's parents informs the parents regarding their child's situation as he feels it is in the better interest of the parents and the teenager.
That question actually involves certain duties that may arise by the doctors. That is beyond this scope. Sometimes I think it's within the context of what are your professional duties. Because sometimes if you have a professional duty to inform those parents, that can be a defense for qualified privilege. And especially if you're speaking about truth, that can you still be able to rely on the defense of justification. So even in that context, you will be more or less safe to inform the parent.
How to prove statement made or acts done not part of discharging their duty as committee member?
I think you meant by how do you differentiate what is done in discharge of formal duties as committee members and your personal capacity, okay? Formal duties basically would mean anything to do with strata. So for example, you are raising concerns about the common property. As the committee members, you are discussing officially amongst yourself on how to improve the area or if there's any concerns raised there. Those are statements made within the official capacity or in discharge of their performance of their statutory duties. What is personal would be something completely unrelated to strata. For example, just because you saw Chairman X and Y going out for drinks with, let's say, a lady, you say that, okay, that's very inappropriate for the chairman to do. Those have nothing to do with or it's not relevant to strata at all, but it's the personal relationship or personal views that he has or relationship with the lady, that those statements would borderline be personal statements. Those, if as committee members you state those statements, those will not be afforded the defense which I've spoken about, the differences between personal capacity and formal capacity.
Thank you, Edwin, for that.
Yeah.
So the next one that we have
Is posting of defaulters list on a notice inside leaves consistent with Clause 6 sub 3 of the third schedule of the Strata Management, Maintenance and Management Regulation 2015? Over to you, Edwin.
Yeah, that I think would be more for the Strata guys to answer, but because I'm doing Strata as well, in terms of defamation, if you're speaking about whether you'll be afforded qualified privilege, yes, you'll still be afforded qualified privilege because it allows you to put on a list. By that very regulation, it allows you to put a list, and because you are putting the list, you will be afforded the defense of qualified privilege. If you distribute those videos, those will be liable. Those statements will be liable, and yes, you would still have to see the entire video, the context of the entire video, to see whether any statements made during in the video or anything insinuating defamatory statements would be decided based on the entire video publication.
Thank you, Edwin, for that. So can we take the last one? Okay. So there is this question on the tips that you have mentioned just now. So this one is a question from the floor itself also. So that asks, would the use of words, for example, presumption might likely confirming my suspicions that a saving grace,
a useful tip
for avoiding defamation?
Yes, yes, I think those kind of crafted statements would definitely be saving graces on how to avoid defamation as a whole. Actually, that helps you in whenever the plaintiff says that you cannot rely on the defenses because you have made those statements maliciously. If you say those statements, usually these kind of neutral statements or saving grace statements helpful to show that those statements are not maliciously made. And because malice is very important in your defenses. Most of the defenses would fail if the plaintiff can show that you are malicious in making those statements. And because you have crafted it in a very neutral and safe way of raising issues or concerns about someone, those could be helpful to show the court that you are not malicious in making those statements.
I'm sorry, guys. I understand that there are a lot of questions from you guys. It must be a very interesting topic at the end of the day. But due to time restriction, we really cannot go on anymore. So if you guys have got any other questions for Edwin, please do post it up. We do have a free consultation for you guys. Just link up to us and then we will actually address to you guys individually.
Before we conclude, I have a few announcements
To make. First, please feel free to join us again for our upcoming talks. Our next talk is actually on 16th of August 2023 on the topic that most of us may come across, which is landlocked by compulsory acquisition, compensation for loss of access. It's definitely an interesting topic that you guys should sign up for. You can also scan our QR code on the screen to sign up for our future online talks. Secondly, Edwin would definitely appreciate if you guys could actually fill in our feedback form and tell us what are your thoughts on our talk. The link to the form will be posted in the chat later on. And thirdly, please feel free to follow us and like our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and also Facebook. Lastly, as per what we have mentioned just now, if you have got any legal questions and you would like to speak with any of our lawyers, be it Edwin or any of our other lawyers, as part of MWK's initiative to give back to the society, we do offer a complimentary 30 minutes consultation over the phone or over video conference. Please feel free to fill in the form on our website. The link is currently posted in the chat box, or scan the QR code on the screen. So to our dear guests today, thank you for joining us. We hope that you have found today's session informative and useful. Thank you, everybody, and we will see you at our next talk. Thank you.
Thank you, guys. Thanks.